I'm a professor at the United States Military Academy, West Point, which is about an hour north of New York City. The courses that I teach are constitutional law and criminal law. Prior to being at West Point and a couple other colleges, I was at the district attorney's office in Brooklyn, which is one of the district attorney's offices in New York City. And before that, of course, I attended law school in the United States as well. One of the things that I did in law school was to assist people who were convicted of crimes and who had been imprisoned. Working under lawyers in the U.S. and at my law school, we had the opportunity to go to prisons and help the prisoners with their parole. And I was assigned to a federal prison, but there is no parole in the federal system in the United States anymore. In those days there was, and students could actually represent prisoners in their parole hearings. They were entitled to parole. A couple of things that I thought about in those early days were, I wonder whether there's ever been a plea of innocence, which I'll talk about later. And I didn't really think about it that much, but I suppose the idea is there's no plea of innocence because people automatically think that a defendant should not have the obligation to prove that he or she is innocent, so therefore maybe it doesn't make sense to have a plea of innocence. But that's kind of a formalistic rationale, but I never really thought about it anymore. And one of the reasons that I was interested in coming to Cambridge is to think about whether there's ever been a plea of innocence before. On one hand, I wanted to find support that in early English law at the beginning of the adversarial system, the late 1600s and the early 1700s, maybe somebody had thought of a plea of innocence and for some reason it had been rejected. I haven't found that that existed at that time or in the United States as well, or even later in the UK. But on the other hand, I thought maybe the plea of innocence is somewhat new and I can propose a new way, and this is kind of my main point today, to try to assist people who are innocent but who've been convicted of crimes. Innocent but convicted of crimes, and often, especially in the UK and US systems, the UK system I obviously know less well, without much of a chance or opportunity to ever be vindicated. Well, why is that? In 2009, a justice of the Supreme Court described correctly, this was part of a dissenting opinion, but nonetheless, Justice Scalia described correctly the state of the law in the United States. That is, the idea that the court has never held that the U.S. Constitution provides that an innocent person who's been found guilty at a trial by a jury or by a judge has the right to be exonerated under the U.S. Constitution. The idea behind that is that the Constitution, or a Constitution, but certainly the U.S. Constitution, is designed to present people with fair processes, defendants with fair processes, but also other people in civil areas like free speech and the right to practice religion as well. But in regard to criminal defendants, the Constitution is designed only to provide fair processes. It's not designed to correct incorrect verdicts. As a result, Justice Scalia, and as you know, the United States has the death penalty, said, in essence, even if we recognize that somebody who's been sentenced to death is probably actually innocent, the Constitution doesn't give us the authority to reverse that defendant's conviction. In another 2009 case, the Chief Justice of the United States said the same thing. And this is the state of the law in the United States today. And that is, a defendant who claims to be actually innocent, I did not commit the crime, may make that allegation, but the court has never decided that it can find in the Constitution a right for an actually innocent person to be exonerated. Whether one believes that is the right way to go or not, there are reasons why courts decide this way. Some of the reasons are philosophical or formal somewhat, and others are practical. And that is, the Constitution provides, as I mentioned, only fair procedures. And there is an idea, of course, that a jury is the best decision maker because it is closer to the facts. It has the ability to analyze the credibility of the witnesses. It has the ability to apply the law as instructed by the judge to the facts of the case. And in addition, it has the ability to decide factual matters, which appellate courts supposedly are not supposed to do in the United States and the UK. And finally, cases have to end at some point. One of the questions, and I'm working backwards and trying to understand why people who claim to be actually innocent have very little opportunity to ever be vindicated or ever exonerated. And I've looked at the notion, and I think we should consider the notion a little bit more about whether there is an intellectual ability actually to distinguish the difference between a fact and law. I've used this example, I just made it up. A father is on trial for perjury because in a child custody case, he was asked by his wife's attorney whether he's ever been convicted of a felony. And he says honestly, this is what he thinks. No, I've never been convicted of a felony. I was convicted of a misdemeanor. Let's say it regarded theft at some point, and the amount of money placed him, the United States still has misdemeanors and felonies, placed him in the category of a felon instead of the category of a misdemeanor. And maybe the amount of money involved could be $500 depending on the state, or $1,000 in other states like California. Is what he said, is his testimony, a question of fact or a question of law? And please feel free to speak up or ask questions or make points. And I question whether we can distinguish whether that's a question of fact or a question of law. And that's important because in the United States, if it were, in the old days, a question of law, then he would be guilty and his appeal would be rejected because of the old mantra, ignorance of the law is no defense. On the other hand, if it's a factual mistake, and we characterize it as such, then the lack of knowledge that he committed a felony can be used to negate an element of perjury, knowingly making a false statement. But how do we characterize it? That is what an appellate court would do, and if it characterizes what happened as a fact, his testimony as a fact, then he could be have his conviction reversed. But if it characterizes his testimony as a question of law, then his conviction should be affirmed. The United States has largely dispensed with this and said that a question of fact or a question of law makes no difference if either one of them negates an essential element of the crime, knowledge that he was lying, knowledge that he was lying or knowledge that he was telling the truth or belief that he was telling the truth, then he should have a defense to perjury. Let's try to make that a little bit more concrete. Harvey Weinstein was an acclaimed movie producer and had an acclaimed company called Miramax. And the company won at least one Best Film Award, certainly in 1998 for Shakespeare in Love, and it produced a lot of other well-regarded movies, at least critically. However, Harvey Weinstein had conflicts with many people, and especially conflicts with women who were actors in his movies or wanted to be actors in his movies. He went on trial for 5 counts of sexual assault in New York City and Manhattan in 2020, and he was eventually found guilty. And this relates, and I'll ask a question, and it's more of a rhetorical question than one that demands an answer, but feel free to offer answers as well. There were 5 charges based on the testimony of 2 complainants, and those 2 complainants, 2 women, testified in his trial that he assaulted them. However, there were possibly up to 100 other women who believed also that he had sexually assaulted them. In the United States, it's very rare that evidence of bad character can be used against a defendant in a current trial. Let's say somebody's on trial for burglary and the prosecution wants to introduce evidence that he committed 69 previous burglaries. The judge will almost always say no to introducing any of those burglaries and will always say no to the prosecution's wanting to introduce evidence that the defendant is in other ways a bad person because he has a criminal record. That can almost never occur in the U.S., except there is an exception. And the exception is if the prosecution is trying to show motive or opportunity or intent, a mental state. In this case, with regard to Weinstein, the idea that he is inclined to sexually assault women, and therefore that inclination means that he should be guilty of an additional charge in the case. One of the charges was that he's a sexual predator. Then those prior incidents with women, that bad conduct can be admitted into evidence. But how does that bad conduct get admitted into evidence? It comes through the testimony of up to 100 other women. The question, or one question in the Weinstein case was, how many of the other women should be allowed to testify? 1, 2, 3, 4, 59, 99. A judge has to make that decision. And the question I've asked, and Weinstein has not abandoned his appeals, and he's not gone to New York's highest court, the Court of Appeals, yet, so we don't know a final answer on this, but this is a critical question in the case. How many of those women complainants should be allowed to testify? Sorry, I said complainants. There were only 2 complainants. How many of those other 100 women should be allowed to testify? The judge said 4. That's a relatively large number in U.S. cases, but I suppose the judge could have said 10 or 15 or 20 or 25, 59, whatever the number would be.
Those 100 women, why has he not been prosecuted in relation to any of them? So when we choose these 4 women, could they not have been on the indictment as other charges?
They could have been, but in this case, my understanding is that the Manhattan prosecutor chose the strongest cases and the strongest complainants because he could have gone through all 100, but some of those 100 women complainants would have been assaulted prior to the lapsing of the statute of limitations. So a number of them would not have been able to testify for that reason. And also, I think the prosecutor was Cy Vance. He actually came and talked in one of my criminal law classes a number of years ago. Very thoughtful. It said, I want to bring the most credible case that I can. He had been presented a couple of years earlier with one of the complainants, and he decided not to prosecute based on her testimony in that case. But he changed his mind a couple of years later and said, I will use her testimony and use her as one of the complainants. And in fact, on that basis, Weinstein was convicted. It's a big question of who are you going to use as your witnesses, and all you need really is one conviction. In this case, if the prosecution had obtained, and it did obtain, conviction with regard to one of the complainants, and had obtained a conviction with regard to the sexual predator charge, then Weinstein would likely have had a life sentence. However, the jury found him not guilty on the predator charge and found him guilty in regard to the interactions, the sexual assault of the two complainants.
So my question was related to the fact that the propensity witnesses are by definition weaker cases.
Yes, yes. Weaker, well, that's interesting because they can't be used as witnesses to show propensity, that he committed this crime. They can be used to show that he engaged in a pattern of crimes, which I suppose is a distinction without a difference. But ideally, the purpose of allowing those prior witnesses is to show his motive, opportunity, or intent, state of mind, not to show that he has a propensity. But it's an interesting case in the Court of Appeals in New York will have to decide it because constitutionally you can't use prior cases to show propensity. But in fact, those prior cases, a jury probably will believe, indicate a propensity, and therefore, because there's a propensity, he's guilty on the present case. So practically, you're right. Is the judge's decision to allow 4 of the other 100 witnesses, possible witnesses, a question of law or a question of fact? I don't know that I have an answer, but I do know if the judge had interviewed all 100 witnesses and said, I believe they're all necessary and they're all relevant, that an appellate court, and allowed all of them to testify, an appellate court would have reversed the conviction, saying somehow this is an abuse of discretion. But would the appellate court then be deciding that this is an abuse of discretion based on a question of fact, which is supposedly up to the judge, or a question of law, which is, yes, up to the trial judge, but then it can be reviewed by an appellate court? The jury also has the opportunity to consider questions of fact and questions of law. I talked to your judge, Nikki, in the class, after the class on Friday, and I asked him, why are there so few successful appeals in the UK? And he said, because courts only take questions of law. The appellate court only takes questions of law, not questions of fact. But that might be a truism, but it seems a little bit formal, because when a jury in a self-defense case is instructed on the law, it is using the law and applying it to the facts of a self-defense case. And it's putting itself in the position of a fact finder, yes, but also someone who is applying the law to the facts, and therefore it's doing two things. And my question has been, why shouldn't an appellate court be allowed to do two things as well? Is that really just something that is historic and a little bit too formalistic? The same is true in the United States, except with regard to the military and one state in the United States. In the military, there are 3 appellate courts for the Army, Navy, and Air Force. And those appellate courts, when a soldier is prosecuted, have the authority to reverse convictions on a basis of fact. They can look at a transcript of a case and decide, it looks like, from our review of this transcript, that the prosecution did not prove guilt beyond a reasonable doubt, and therefore we will not only reverse the conviction, but we will acquit the defendant. And there won't be another trial. One state can do that. So far as I know, and the research seems to indicate that that's the limit. The military and one other state can reverse convictions based on a factual determination. The Blackstone ratio questioned whether we should allow 10 people to be freed, 10 guilty people to be freed, to save one innocent person. That's a somewhat inexact reference, because we'd have to consider whether we're freeing 10 people who have murdered somebody, 10 people who've committed robberies, or 10 people who've committed lesser offenses. But nonetheless, the point is that we've rarely, if ever, considered how many people should be exonerated or should be freed, guilty people or innocent people, in a justice system. I don't know that I have the answer, but I don't think that our countries have very much considered what should be the answer. Therefore, it's somewhat easy not to consider the number of people who have been convicted but who are actually innocent. So the question is, or one question is, how many people who are convicted are actually innocent? It's very difficult to know, of course, but this is one study from 2014. It's probably the most prominent study in the United States in regard to innocent people who have been convicted and sentenced to death. As you can see, we have a total from 1973 to 2004 of almost 7,500 death penalties administered by judges. Up to today, there have been since 1973, I think from 1976, there was a time when the death penalty was abated in the United States for 4 years, but between 1976 and today, about 1,569 people have been executed. This study found that 4.1% of the defendants who remain under death sentences will be exonerated. The reason that a lot of people believe this study is more reliable than other studies is that it focused on death penalty cases. And a number of death penalty cases, of course, have blood involved because there cannot be a death penalty unless there's a murder. And some death penalty cases involve rape as well. And in rape cases, sometimes there are other biological fluids, such as semen, that are recovered and saliva. And because of that, in those two cases, they are more likely to produce evidence that can be DNA tested. And DNA tested evidence, of course, can make us virtually certain that some people who have been convicted are actually innocent. That is to say, the first exoneration of DNA occurred in the United States in 1989. If police saved the blood on the shirt of the victim from 1980 and were able to examine it in 2021, if the defendant is still in prison and we find that the blood did not belong to the defendant, and we know that there was one assailant, only one assailant of the victim from 40 years previously, we know that this defendant did not commit that crime. We're fairly certain. So we can say that we have an idea that 4.1% of the people in death penalty cases sentenced to death are actually innocent. One question to ask is that percentage too high? Is it too low? Or is it an acceptable percentage? What does it turn out to be as to a number? In the United States, we're at a low right now. There are probably about 2 million, 2.1 million people in prison. It varies by year and by decade, but generally we can think that the number of innocent people in prison, if you go on a basis of 4.1% innocent people, could range from 50,000 to 100,000. There are 10 million arrests in the United States each year. Probably about 66% of the people who are arrested are actually convicted of a crime, and another 14% or so have their cases dismissed. We can do all kinds of configurations, but we end up having to ask whether 4.1% is too high, too low, or an acceptable ratio of innocent person convictions. This is incredibly interesting to people who follow this. This is from the study also, the 2014 study. And I mentioned that we can be fairly certain in some cases where DNA is present. But the reality is DNA, according to these authors, and this is my conclusion as well, is not a great tool because there are so few cases relatively with DNA evidence with which to exonerate innocent people. Only 13 of the death row exonerations since 1973 resulted from post-conviction DNA. Today, prior to trial, in all cases where there's evidence that can be DNA tested, it will be tested. There's no question. So that means the number of people who are exonerated because their DNA was not tested in the 70s, 80s, 90s, and early 2000s will continue to diminish. What then is a contributor to innocent person convictions? And these are the top 8, almost uniformly. Professor Edwin Borchard was a law professor at Yale, and in 1932 proposed that essentially these were the 8, but studies since then, more scientific studies, have reached the same conclusions. I'll go forward one and then come back. Conceptually, why are innocent people convicted? That is to say, if judges and jurors are reasonable and fair people, and most are, then if all the facts in a case were known, and this is idealistic, of course, but if they were, then nobody would ever be convicted. So to some extent, to some large extent, the only reason that any innocent person is ever convicted is that all the facts are not known. Why are all the facts not known? Well, misidentification is usually considered to be the number one reason that contributes to innocent person convictions. Somebody makes a mistake and identifies the wrong person. But as you look through that, the question that I like to ask myself, and that I've recently thought about more and more, is what is the central characteristic of all of those contributors to innocent person convictions? Human error, or human foibles. Except with witness perjury. Witness perjury usually turns out to be a cooperating witness for the prosecution. But those are very few who receives a benefit for testifying against the defendant. All of those relate to human error, not to science or not to DNA, but to something that a prosecutor, a defense attorney, a police officer did improperly, not with malevolence as it turns out. The data seem to show that innocent person convictions do not result from framing or animus toward a particular person or a particular group, but they result from these kinds of errors. If DNA evidence is not a high exonerator, even in the death penalty cases, and human error is a critical cause of innocent person convictions, then it seems that we might be stuck with a lot of innocent person convictions with no way to prevent them. Is 4.1% too high? If we don't have a way to prevent them, if this is the best we can do, and in the US, a lot of us are now saying that the innocence movement has gone as far as it can go. It's done a fantastic job. That is the innocence movement identifying these 8 contributors to innocent person convictions. But now what do we do with this human error? there's a book out, a recent book, Noise, by 3 professors. One was Professor Kahneman, a Nobel Prize winner in economics from Princeton, who discusses and has discussed that bias is almost inalterable. Error is almost inalterable. I presented this concept of the Plea of Innocence at a conference in 2007. And I've tried to develop it a little bit more since then. And the idea that people come up with, and resistance to changing the adversarial system, and I do advocate changes to the adversarial system, is that if we change the adversarial system, because people have a default that the adversarial system depends on changing procedures. Remember Justice Scalia in the beginning slide? He said, there's not much we can do it's just the way of life. It's just the way law is. We can't do anything if the best we can do is to focus on processes and procedures. And if we're trying to adjust processes and procedures to eliminate these 8 contributors to, or reduce these 8 contributors to innocent person convictions, but now we've reached the end, we've done some of the best work that we can do, where do we go from there? Do we change procedures more so that more guilty people will escape responsibility so that more innocent people can be exonerated? I've said I don't think we have to do it that way. There's probably another way that we can do it. And I would argue that the number of innocent people can be reduced without reducing the number of guilty people who are eliminated from responsibility as well. And this is the formal part of the process. The defendant may plead innocent. The lawyer must affirm a good faith belief in innocence. That's not complicated at all in the US. All a lawyer has to do, a lawyer in New York, for example, where I'm admitted, is to affirm to a judge on information belief, my good faith argument is that my client is innocent. That would be enough to satisfy that criterion. And a defendant must agree to be interviewed by the prosecution. In return, the prosecution is required to search for exonerating facts that the defendant identifies. A defendant who speaks to the prosecution prior to trial, and I'm not talking about in a police precinct or police station shortly after arrest, but sometime prior to trial after the defense has discovered some of the evidence of the prosecution and the prosecution has had the opportunity to consider possible defenses by the defendant. If a defendant in that situation, and I can discuss this more, but I'll try to sum up now, talks to a prosecutor, it's very difficult for a defendant to escape, if he or she is guilty, a conviction. Prosecutors are very good at following up on defendant statements, but we could talk about that as well. I've suggested that the burden of persuasion should be higher than beyond reasonable doubt, and that adverse inferences against the prosecution or defense may be made for acting in bad faith. I'll address just one last point, and that is the defendant's actions may create an inference of innocence. In sexual assault cases, there is the concept of an outcry witness. The sexual assault complainant may remain silent for a long time. Long is relative, of course, but whether that time is a day or a week or a month, when the complainant eventually does tell somebody, then that complainant may testify in court. There are some conditions attached to this, that the complainant told me that he or she was assaulted by the accused person on such a date. That, of course, that testimony by that third person, the person to whom the complainant said that he or she was sexually assaulted, would normally be hearsay and inadmissible testimony. But all states and the federal government in the U.S. have determined that that outcry witness may testify as an exception to the hearsay rule. And the theory is that a complainant in those cases, in that type of situation, especially if she or he makes a prompt assertion to a third party, like a friend, is a complainant who is telling the truth. And that's especially true when the defense is that the complainant is lying. And I would discuss this a little bit more in the upcoming book that I mentioned in the announcement for this talk. But isn't there something out there similarly that indicates that defendants who engage in some actions are similarly truthful and similarly trustworthy? And if they claim innocence promptly, for example, after being accused or engage in certain actions, then shouldn't they have the opportunity as well to allow those prior actions or prior statements, normally hearsay and inadmissible, into their trials? In 2010, and I'll finish on this, this is a criticism of the concept of the plea of innocence by a professor named Jeff Cassell. He's a former federal judge in the United States. In 2010, there was a symposium on the article that I wrote about the plea of innocence. He said, if Bakken's theory were put in place, thousands of guilty people would be exonerated because guilty people would claim to be innocent and they would use these procedures to escape justice. And he went on to describe that and believes that the procedures are fair as they are, and he rejects the 4.1% percentage and believes that the number of innocent people convicted, the percentage of innocent people convicted, is actually under 1%. I'd be happy for any comments or questions or points.